representative in court?
Yes, my lord.
My lord is online, my lord.
Who is online?
Defendant representative, my lord.
Is there Mr. Stanley or no, sir?
Challenging.
Stanley what?
No, sir, my lord. No, sir. Sir.
What's his position?
Company secretary, my lord.
Answer?
Yes, my lord, I appear for the claimant, M.O. Egwari.
Yes.
With due respect, my lord, B. Mbagu, I humbly appear for the defendant.
Okay.
Okay. Court judgment. As usual, I'm going to read the release as endorsed on the complaint.
As God pleases.
As God pleases.
I'll go to the issue framed by counsel to the parties and then go to the decision part of the judgment. I'm leaving out the summaries of pleadings and arguments of the parties. But they are in the judgment. So when you pick your copies, you see the summary there.
As God pleases.
Okay. This case was filed on February 2, 2023 by the claimant via complaint, through which he is seeking for the following reliefs. 1. Another of these honorable courts mandating the defendant to pay the claimant the sum of 5,291,844 naira, being the balance of the sum of 18,429,924 naira as part of the claimant's redundancy benefit. 2. Another of these honorable courts mandating the defendant to pay the claimant the sum of 641,202 naira, being the claimant 3 months basic salaries in lieu of notice. 3. Another of this honorable court mandating the defendant to pay the claimant the sum of 1,950,000 naira as ex-gratia lump sum payment benefit. 4. Another of this honorable court mandating the defendant to pay the claimant the sum of 235,107 naira, being the claimant's leave allowance. 5. Another of this honorable court mandating the defendant to pay to the claimant the sum of 213,734 naira, being the claimant's Christmas bonus. 6. Another of this honorable court mandating the defendant to pay 21% interest per annum per month on the judgment sum until the same shall be fully liquidated by the defendant. 7. Any order or further orders this honorable court shall deem fit to make in the circumstances of this case. In the defendant's final written address at page 188 of the record, it counsel raised an issue for the determination of the court this way. Hold on, please. Let me try and switch off the other.
As the court pleases.
I think it's the one echoing. Yes. Can you hear me now, please?
Yes, my lord,
Yes,
clearly.
my lord.
Okay, it's not echoing again. Sorry about that. In the defendant's final written address at page 188 of the record, its counsel raised an issue for the determination of the court thus, and I quote, whether the collective bargaining agreement dated 1st December 2018 between C Truck Group of Companies and Maritime Workers Union of Nigeria, open bracket Seamen/NIWA and Water Transport Branch, close bracket, applied to and or formed part of the employment contract of the claimant with the defendant hearing. And as such, whether from the evidence-led hearing, the claimant is entitled to any of the various sums of money claimed in his complaint and statement of fact based on the said collective agreement or at all. Like I said, I'm leaving out the summary of the arguments.
As the court pleases.
As the court pleases.
In the claimant's final written address at page 215 of the court record, his counsel raised an issue for the determination of the court as, and I quote, whether the claimant is entitled to the redundancy benefits which the defendant is yet to pay in line with the terms and conditions as stated in the agreement dated 1st of December 2018, and also the conventional practices of the defendant, end of quotation. Yes, I now go to the decision part of the judgment.
As court pleases.
Okay. In response to paragraphs, sorry, I have read through the facts of this case as pleaded by the parties, including the testimonies of the parties. I've also perused the written argument of counsel to the parties, including the cited authorities, both case and statute laws. From all of this, I'm of the considered view that the following issues need to be resolved between the parties by the court. One, is the collective bargaining agreement of December 1, 2018 between C-Truck Group of Companies and Maritime Workers Union of Nigeria, open bracket Siemens/NIWA and Water Transport Branch, close bracket, applicable to the contract of employment between the claimant and the defendant. Two, is the claimant entitled to the relief he is seeking for before the court, which are A, 5,291,844 naira as balance of his redundancy benefits. B, 641,202 naira as his 3-month salary in lieu of notice. C, 1,950,000 naira as ex gratia. D, 235,107 naira as his leave bonus. E, 213,734 naira as his Christmas bonus. And F, 21% interest per month on the judgment sum until liquidated. So resolution of issues now. The contract of employment between the claimant and the defendant is a private contract of employment, which is formally known as master and servant relationship. In such contract, parties are strictly bound by their terms and conditions of service as stipulated therein. As these terms and conditions regulate the employment relationship, such as how the employment is determined, the required notices before the determination, wages to pay, and so on. A decided authority is referred to it there. In paragraphs 1, 5, 6, 11, and 35 of the statement of fact, the claimant pleaded and tendered in evidence as exhibit is letter of confirmation of employment, exhibit C1. See page 25 of the record. Other documents he tendered in evidence as exhibit are his severance letter dated October 28, 2021 at page 28 of the record as exhibit C2, the collective bargaining agreement of December 2018 as exhibit C3, which is at pages 118 to 163 of the record, his statement of account as exhibit C4 at page, which is at page 36 of the record, and his September 2021 pay slip as exhibit C5 at page at page 38 of the record. In paragraphs 5 and 8 of his statement of defense, the defendant counsel averred that the collective agreement referred to by the claimant is not applicable to his case. The defendant further averred that the claimant's employment with the defendant was strictly regulated by his contract of employment as stated in his letter of employment. The defendant continued that the claimant was neither a junior nor an intermediate staff of the defendant. Rather, he was a health, safety, and environment manager of the defendant. From the content of the parties, from the contentions of the parties, as stated above, the question remains whether the collective bargaining agreement of December 1, 2018, which is exhibit C3 before the court, formed part of the employment contract of the parties in this case. It is a settled law that the contract agreement It is a settled law that contract agreement is enforceable where it has been incorporated into the terms of employment of the parties. Collective agreement is the handbook law of a contract, especially in a private employment, and it is only binding on the parties where it is expressly or impliedly incorporated in the contract of service, but not otherwise. Um, Two decided authorities are referred to there. Section 1.02 of Exhibit C3, the collective agreement, at pages 118 to 163 of the record, limits the application of the collective agreement in question to junior and intermediate level staff of the defendant. However, the claimant was employed by the defendant as its base nurse, where Exhibit C1, the letter of confirmation of appointment dated September 1, 2002, at pages 25 to 27 of the record. And in paragraph 7 of his reply to the statement of defense, the claimant admitted that he was a senior staff of the defendant as at 2021, when his employment was determined for redundancy by the defendant. In other words, the claimant was a senior staff of the defendant. He was neither its junior nor its intermediate staff at the material time, and I so find.
As the
In
court, please.
justifying the application of the collective agreement in Exhibit C3 to this case, the claimant pleaded in paragraph 8 of the statement of facts that it is the conventional practice of the defendant as one of the major operators in the maritime industry to pay redundancy benefit to its workers, both junior and senior, declared redundant by the defendant in line with any current collective agreement in the company. See also the argument of counsel to the claimant in paragraph 10 of the claimant's final written address on this issue. However, the claimant did not show the court any of these supposed conventional practices of the defendant where it used a current collective agreement between it and its junior and intermediate staff to pay redundancy benefit to senior staff that it declared redundant. It is settled in law that facts admitted need no further proof. See Section 123 of the Evidence Act 2011 as amended, and some cases are referred to there. Since the claimant could not show the court the conventional practice of the defendant, where it applied the collective agreement that was expressly meant for junior and intermediate staff to its senior staff like himself, I find and hold that by virtue of the provisions of Section 1.02 of Exhibit C3 at page 125 of the record, the said Exhibit C3 is not applicable to the claimant case, who was a senior staff before he was declared redundant by the defendant.
As the court pleases.
Furthermore, as beautiful as the argument of counsel to the claimant is in his attempt to establish the conventional practices of the defendant appear to be before the court, there is no evidence of such conventional practice before the court to enable the court apply it, or at least form its opinion that Exhibit C3 is impliedly incorporated into the contract of employment of the claimant. Address of counsel, no matter how beautifully and brilliantly presented, does not replace evidence in this case. In the case of BFI, Group Company versus BPE, citation supplied, it was held by the Supreme Court that it is not the demonstrations and brilliant construction of sentences in an address that can make up for lack of evidence to prove or establish a fact or dispute and demolish a point in issue. A cited authority is also, another cited authority is also referred to there. In the same vein, the law is trite on pleadings that, however strong and convincing the averments may be in the pleaded facts, without evidence in proof thereof, the pleadings are deemed abandoned. This is because evidence is required to be led to prove the fact relied on by the party or to sustain allegation raised in the pleadings. In other words, averment of facts in pleadings are not evidence and can never be so construed. The fact so averred must of necessity be proved by evidence except those facts are admitted by the adverse party. A decided authority is referred to there. In fact, three decided authorities are referred to there. It is the court's finding, therefore, that pleadings do not constitute evidence, and where such pleadings is not supported by evidence, either orally or by any document, it is deemed to have been abandoned. Some other decided authorities are referred to there, and I so hold. In
As the court
addition,
pleases.
the law is very clear that in civil cases, the burden of first proving existence or non-existence of a fact lies on the parties against whom the judgment of the court will be given if no evidence was produced on either side. Regard being had to any presumption that may arise on the pleadings. See Section 133 of the Evidence Act 2011 as amended. The claimant was first of all required to prove to the satisfaction of the court that even though he was declared redundant as a senior staff of the defendant, he was entitled to benefit from the collective agreement in Exhibit C3 by virtue of conventional practice of the defendant. But the claimant failed to discharge this burden, and I so hold. In the
As the
same
court
vein,
pleases.
I find that there is nothing in Exhibit C1, the letter of employment at pages 25, pages 25 to 27, that expressly or by implication incorporated the collective bargaining agreement of December 1, 2018 into the contract of employment between the parties in this case. Consequently, I hold that the collective agreement of December 1, 2018 in Exhibit C3 are not applicable to the claimant's case.
As the court pleases.
Issue 2. Is the claimant entitled to the relief he is seeking for between the claimant, before the court? In the claimant's letter of, sorry. In the claimant letter of severance of employment by redundancy, Exhibit C2, at page 28 of the record, it is stated in part that your redundancy, and I quote, your redundancy benefit includes your 3-month basic salary in lieu of notice, end of year bonus, annual leave allowance, and leave enchantment are prorated where applicable and paid together with your redundancy benefit in accordance with your letter of employment and condition of service. End of quotation. In paragraph 11 of the statement of defense, the defendant averred that the claimant was paid his 3 months salary in lieu of notice, end of year bonus, and annual leave allowance together with his redundancy benefit as stated in the severance letter dated October 28, 2021. The defendant went on that the total sum paid to the claimant is 13,138,080 naira. only, which he accepted in full and final settlement of his redundancy and terminal benefits. See also paragraph 12 of the statement of defense, the pay check, exhibit C5 at page 38 and D8 at page 73, 74 of the record. It is worthy of note that the monetary reliefs, which is release 1 to 5 and 6, the claimants are based on the content of the collective bargaining agreement, are based on the content of the collective bargaining agreement in Exhibit C3, which I have held above not to be applicable to this case, and I have also discountenanced the said exhibit in this judgment. Consequently, I hold that reliefs 1 to 6 of the claimant for various monetary claims in the instant case and for interest thereon are not backed up by satisfactory evidence. As a result, I hold that this case lacks merit and the entire reliefs claimed are accordingly declined.
Has
Consequently,
God
the
please?
whole claim of the claimant are hereby dismissed for lacking in merit. Judgment is entered accordingly, and I make no orders to cost.
As the court pleases. We are very grateful, my Lord. We are truly grateful.
Okay.
Much
Eguari.
obliged, my Lord.
Mr. Eguari?
Yes, my Lord, I'm here. I was trying to reconnect. My Lord, we are grateful for the judgment of the court.
Okay. By God's grace, I think by Friday you should be able to get your copies
As God pleases.
of the judgment. Yes.
As
Okay.
God pleases. Thank you, my Lord.
You're welcome.
My Lord, we are grateful. Thank you very much.
Okay. Thank you very much.
All right, my Lord.
Okay.
Hello, Stanley. Hello. Hello. Hello.